Hello, everyone, and welcome to Compliance Cafe, your go to place for decoding the Companies Act and its unending rules, one simple explanation at a time. On today's episode, we have Shaili Shah, a compliance expert, who's going to help us decode the beautiful mess that Section 186 of the Companies Act 2013 is. Let's dive right into the video, Shaili. Tell us, what is Section 186?
So, Section 186 of the Companies Act 2013 speaks about loans and investments by the company. It basically regulates how a company can give loan, provide guarantees or securities, or make investments in another companies. So, to understand, let's divide the section into two parts. So, the first part covers about intercorporate investments made by the companies along with the limitations and restrictions placed by the Act. And the second part governs loans, guarantees, securities by the companies along with the various compliances that a company needs to undertake while making such investments or providing loans, guarantees, securities. So the section is designed so that the companies do not use their funds recklessly and expose their shareholders or creditors to unnecessary risks.
Okay, so let's move ahead. Now, let's start with the first part of Section 186, the investment part. Now, when a company makes an investment in any other company, what rules come under play? Can you explain that?
Sure. Subsection 1 of Section 186 states that a company is not allowed to make an investment through more than two layers of investment companies. Now, what is a layer? So, layer in relation to holding company means its subsidiary. And what is an investment company? An investment company is any company whose principal business is making investment in shares, securities, debentures, etc. Also, if 50% of total assets of any company are investments, or if 50% of the total income comes from such investment, then it is deemed as an investment company. Now, for example, if A makes an investment in B and makes B its subsidiary, and B further makes an investment in C, and if both B and C are investment companies, then the law states that the investment has to stop at C. C cannot make a further investment in the investment company. Now, actually, the Ministry of Corporate Affairs has introduced a new rule, Restriction on Number of Layer Rules 2017, which states that any company except for banking, insurance, NBFC, and government company, any company cannot have more than two layers of subsidiaries. So, actually, the concept of investment company will be redundant once these rules are published. This is to avoid creation of multiple corporate structures and to promote transparency.
Okay, so moving on. We understand that a company cannot make an investment in more than two layers of investment subsidiaries, like you mentioned. But is there any exception to this rule?
Actually, yes, the Companies Act does allow additional layers in two scenarios. Firstly, if an Indian entity acquires any company which is incorporated outside India and such foreign entity already have two layers of investment subsidiaries, then the acquisition by Indian company will be permitted. Secondly, a subsidiary will be allowed to have further investment subsidiaries if doing so is necessary to meet any legal requirement.
Okay, so with the last question, we come to an end with the first part of Section 186, which was investments. Now let's hop on to the second part, which is loans, guarantees, and securities. So, what are some key compliances the company needs to keep in mind while entering into such transactions?
Okay, so section 186(2) of the Act states that a company is not allowed directly or indirectly to give any loan, guarantee, or security to any person or a body corporate or acquire securities of another body corporate exceeding 60% of its paid up share capital, securities premium, and free reserves, or 100% of its free reserves and securities premium, whichever is higher. However, Section 186(3) allows the companies to cross these limits of 60% or 100% if the authority is given by the members of the company by passing a special resolution in the general meeting. So, to sum it up, if the company wants to give loan, guarantee, or security or make an investment within these prescribed limits, then the board resolution will suffice. However, if they want to cross the limits, then the members have to pass a special resolution and give the authority to the board.
Okay, Shelly. Throughout this episode, you have mentioned words like loan to a person or guarantee to a body corporate. Could you explain these terms to us?
Yeah, so the word person does not include any individual who is in employment of your company, and the word body corporate means any company which is incorporated outside India, but it does not include a cooperative society and any body corporate specified by the government.
All right, that's quite simple. Okay, moving on to the next question. Are there any exception where a company can give loans, guarantees, or securities, or for that matter, make an investment into other companies without having to take any of the above mentioned approvals?
Yes, there is an exception. If the company wants to give loan, guarantee, or security to its wholly owned subsidiary company, or if it wants to acquire securities of its wholly owned subsidiary company, then the approval of shareholder is waived off. However, the board approval is still mandatory. In fact, Section 186(5) places the board at a higher level. The resolution is not passed by a simple majority. All the directors present at the meeting have to give their consent for the resolution to be passed. So to sum up, if the company wants to give loan, guarantee, security, or make an investment in its wholly owned subsidiary company, then shareholders' approval is waived off. But in all these cases, board approval is still required to be taken.
Okay, so now this is an interesting question. Since we've spoken about approvals a lot, can the board delegate its powers to anyone else under the Companies Act 2013?
As we know, Section 179(3) of the Act allows the board to delegate some of its powers to any of its committee or director or any of the principal officers of the company. However, as I mentioned earlier, Section 186(5) requires the consent of all the directors who are present in the meeting for approving the transaction. So, this can be interpreted as this way. Once the board has approved the transaction in the meeting, the execution part of the transaction can be delegated to its committee or the managing directors or the principal officers of the company.
Great. Okay. So now you've also spoken about investments a lot. Can you explain the term investment, and does investment include investment into assets like land or any other such investments?
So Section 186 strictly speaks about investment in shares, securities, debentures, etc. And investment in land, plant and machinery or any other such kind is not included in this section.
Okay. So moving on, let's talk about some compliances that we need to keep in mind before and after entering into transactions under Section 186.
Yes, so as we know that basic shareholder and board's approval is required. Now there are some other compliances that the section requires us to follow. Firstly, the company has to disclose in its financial statement the details of loan, guarantee, security, investment, and the purpose of such funds. Then the company cannot give a loan at an interest rate which is lower than the interest rate of the government security. Thirdly, whenever a company enters into such transaction, the company needs to maintain a register in Form MBP2, which includes the particulars of such loans, guarantees, security, and investment. And lastly, this register needs to be maintained at the registered office of the company, which will be open for inspection for the members of the company.
Okay. So now to sum it up, are there any companies that are completely exempted from the application of provision of Section 186?
So actually, I would not say entirely exempt, but Section 186, except Section 186(1), the entire section is not applicable to a loan, guarantee, or a security provided by the banking company, insurance company, housing finance company in its ordinary course of business, or a company who is engaged in the business of financing the industrial enterprises. Secondly, it will not be applicable to any investment made by an investment company, any investment made in shares which are allotted under Section 62(1)(a) of the Act, or any investment made by an NBFC whose principal business is acquisition of securities.
Okay, Shelley. Now that we've gone through all the procedural aspects of Section 186, why do you think the entire section is so stringent? Why do you think it's so strict?
So I'll tell you why the section was introduced. It is basically to prevent the misuse of funds. So earlier what used to happen, the companies used to give large amount of loans to its sister concerns, to its related parties without any proper oversight. And this used to lead to losses, frauds and conflict of interest. So now minority shareholders were left exposed to unnecessary risk. So to avoid this and to ensure that companies maintain transparency in the transactions, and so that the regulators and investors can track the fund movements of the company, this section was introduced. It basically acts like a speed limit for the companies.
Okay. So, Shelley, let's end this episode talking about the penalties for non compliance under this section.
If a company is in non-compliance with section 186, it will be punishable with a fine of rupees 25,000, which can extend up to rupees 5 lakh rupees. And every officer who is in default will be punishable with an imprisonment for a term of 2 years, along with a fine of rupees 25,000, which can extend up to rupees 1 lakh.
Okay, Shelley, thank you so much for clearing all our doubts. We have pretty much covered everything that we could under this section, right from definitions, what is exempt, what is not, the penal provisions, and most importantly, why this section even exists. For more such content, please follow us, and we'll see you in the next episode.